So what I'm going to talk a little bit about, and then I'll turn it over to Camila, is the Office of Technology Transfer and Commercialization. You can read this. Basically, what we try to do in this office is help protect intellectual property that you may generate during your research, and hopefully you will generate intellectual property that has value, and then help you in terms of transitioning that intellectual property to some commercial value, potentially through a company or through trademarks or other types of mechanisms. And then the third thing is when you're working with companies at different levels, the office helps handle those agreements that you need to develop right at the start when you're working with these companies. So we have a whole range of kind of standard boilerplate agreements that we can use at least as a starting point to develop in relationships with companies. The policies that regulate these activities are in the Board of Regents Policy Manual 4.34. You've heard it mentioned a couple of times before. We mentioned the conflict of interest statements and disclosure statements that you need to make. Things that you do as part of your paid employment at SDSU that relate to your career, that are funded by the university or an outside grant, or that are conducted as part of your work here using university facilities. Any novel intellectual property that you develop is actually owned by the Board of Regents, and then it's provided back to ownership through the university. So the Board of Regents entrusts each university with the intellectual property its faculty members develop. And so what you develop here during your course of work is owned by the Board of Regents and SDSU, or through students that you have that are funded by your projects or work in your lab is owned by the university. When that material is ultimately commercialized, if it is, the university splits the license revenues, the income that would be generated from that 50-50 with inventors. Most universities, it's a much lower ratio of sharing. So that's one of the things that's nice about SDSU is it really incentivizes researchers to be creative because you get a bigger pool of that money. What this slide talks about is students. Now, undergraduate students are not subject to this. Unless they're hired by you in a research lab or conducting research under your direction, or there's some strong tie to university support, facilities, equipment, so forth. If the students create something, that's their own intellectual property. They own that. Now they can use our tech transfer services if they would want to for a fee. We'll take a share of that, but that's separate. So students are a little bit unique class, again, unless they're being supported through your lab or using equipment on the university system. The steps of this process, communication, frequent communication is really valuable. So if you have a creative idea that you think has merit, and again, it can be a tangible product, it can be an idea, a trademark, something like that, start by contacting the Tech Transfer Office right away. What we would suggest that you do is initially file a invention disclosure document. It's a fairly simple 3-4 page document that you can fill out in 10-15 minutes at most and send that into the office, and then we'll have you in, discuss your idea, flesh that out a little bit more, and then we use that document to make a decision, help make a decision in terms of whether it's a patentable idea or if somebody has already discovered that or not. So if it's novel, nobody else has disclosed that or made that claim or has a patent, that's the first step. And then the second step is to do due diligence to see if it actually has commercial value, because the patent process costs a fairly substantial amount of money, anywhere from $5,000 to $20,000, $30,000 per patent. So we want to make sure that the patent will pay for itself as a minimum and hopefully generate revenues in addition to that. We ask you to do that invention disclosure really quickly, because if you go to a conference or obviously publish this in a paper or an abstract, any public disclosure of this information could potentially void that from being a patentable object or patentable information because you made a public disclosure. Now, if you have made a discovery, you've given a presentation someplace, If you come immediately after that to the office, we can file, you can file an invention disclosure, and then we can file a provisional patent application. And as long as that's done within 12 months of when you provided that, given that public disclosure, you're still protected in the United States. It doesn't help you overseas because there it's just fair game. The United States has this clause that if you file a provisional patent, you have a 12-month window in which to file a full patent, so there's a window of time that is protected. But if at all possible, before you disclose this in any venue, even a classroom, come in, file an invention disclosure, talk about it with us, and then we will decide whether or not to submit a provisional patent application. I mentioned agreements. Some of you potentially will work with startup companies, existing companies, collaborators at other universities, and so we have a range of probably 15 or 20 boilerplate documents that we can use as starting points to work through agreements. It's much easier to create a legal agreement before you start doing something rather than after you've gotten into the weeds with a group. The first step, confidentiality, non-disclosure agreements are kind of the first level that you would want to approach if you're dealing with some outside group. Once that is filed, then you can be free to get into the weeds, so to speak, a little bit more on your ideas. You have some protection, at least, that other group won't disclose that to other sources. Material transfer agreements are used if you're sending samples to some third party or a third party sending samples to you. And then there's a whole range of research collaboration, sponsored research, sponsored service agreements. I don't know what a touring agreement is. I've never dealt with one of those. Maybe that's touring a facility. That's what I guess Camila says it is. Sponsored research agreements, the name research means you're actually doing some research, hopefully discovering something unique. A sponsored service agreement, for example, a company would come to you and say, we want you to do steps 1, 2, and 3. We'll provide all the materials, the funds. We want you to provide us with the data. And so any intellectual property, there would be no intellectual property generated or owned by the university or the researcher in a sponsored service agreement. We're simply providing a service, as opposed to a sponsored research agreement where we actually could hopefully would generate that knowledge. Facility use agreements. We have agreements where companies can come in and use facilities and equipment at the university for a fee, or we can use facilities or equipment at some outside vendor's location for a fee. And then, of course, licensing agreements and royalty distribution agreements if we generate some intellectual property and it's licensed and it starts generating income. So all of those agreements are in place. They're boilerplate agreements. We've had really good luck with providing those to third parties. The third parties make a few modifications, send it back to us, and within a matter of sometimes a couple of hours, we can have a signed agreement. This is one of the things that makes SDSU really pretty unique. A lot of universities, it can languish in offices for days, weeks, months before these agreements get taken care of. And by that time, sometimes the enthusiasm, excitement is tempered down, and, well, they decided to go on with somebody else. So we make that a real selling point of our university. So what is intellectual property? Definition is up on top, created by intellectual activity. It's not naturally occurring. There are various types of intellectual property. Intellectual property protection, again, allows the invention to be protected. It gives the inventor a monopoly on that information in exchange for disclosing it to the public. And there are a number of rules in the Federal Register and so forth to cover that. The Bayh-Dole Act is something that you'll hear fairly frequently because of the fact that most of the research, or quite a bit of the research that's carried out at the university, is funded by the federal government. There was concern a number of years ago, well, if we discover intellectual property at SDSU using federal funds, shouldn't the federal government then own that intellectual property? But what the Bayh-Dole Act did was it said that the universities, that receive those federal funds. They develop intellectual property. The universities can then take advantage of that intellectual property with the intent of commercializing it for the public good. The government felt that the benefit of providing the money to the university to generate the intellectual property would be reimbursed through increased economic activity, and they would get their money back through taxes. So instead of the federal government having a clamp and holding all this and trying to, monitor all that, they felt it'd be better to distribute that power down to the universities to carry that out. So we have provisions in your contracts then that allow us to do that. And so technology transfer offices are found typically at all major research universities, and they're charged with protecting and then commercializing this intellectual property. I mentioned cost of patents. It can range up to $30,000, and if you're patenting in multiple countries, you just multiply that $30,000 over and over again. And so when we get invention disclosures in and we're making decisions on whether it could be patented, we're thinking about, first again, is it patentable? Has somebody already discovered this and disclosed it? And then second, what's the market? And in what countries, how many countries would we need to patent it? So there's a balance between the cost of getting a patent and the potential license revenue that you generate from that. Potential are, if you ultimately get a patent, one thing that we'll look at doing is finding existing companies that are in that field. Would they be interested in licensing that technology because they already have the production, the distribution, the client base? And so that's a fairly simple mode to do that. But we also have startup companies that have begun through developing intellectual property. It's a little longer road. The benefits can be even greater than simply licensing. And then in some cases it might be you have 80% of the solution, but it's not quite ready for prime time, so to speak, and so it needs a little bit of additional research. And that might come from another university, it might come from the company that you're participating with, and so you can get multiple patents on a particular process to ultimately get it to the stage where it has commercial value. So that's potential. Those are kind of three of the potential outcomes.
Dr. Gibbons covered a little bit of what I'm going to be talking. So there are a few different types of IP protection. Patents that go for ideas, copyrights are expressions, trademarks identifying goods or services, and trade secrets, its value in the secret. So when we talk about patents, the first thing to know is that it grants you the monopoly of that specific technology. But a lot of people think that it's granting the inventor the right to do whatever they want with that technology or that IP, which is not correct. The correct answer is to say that it's granting the inventor the protection from others using that technology without a license agreement or without paying royalties. So that's basically what a patent is. You only get a protection in the countries that you have filed that patent. So for example, if you file here in the United States, you're not going to get any protection outside of the United States and vice versa. So patentability. There are a few requirements that need to be filled out according to the 35 United States Code, sections 101, 102, 103, and 112. And that is, it has to be novelty, new, it's not available out there in the market. It has to be non-obviousness. So not anticipated by a skilled art or someone has already developed something similar to that. Enablement. A skilled person in that specific area can understand that and they know how to reproduce your technology or your IP. For example, I have a law degree and then Dr. Gibbons present to me with a biochemistry technology and I'm not going to be able to reproduce that because I'm not skilled in that area. But if another biochemist will be able, that is the enablement. And then it has written description, utility, best mode, statutory, and subject matter. As Dr. Gibbons mentioned before, there are a few bars that will avoid you from getting a patent. So that's why we want you to talk to the tech transfer office early and often as possible. One of them will be if you go to a conference, to a meeting, you publish a paper or anything similar to that, you have 1 year after that publication or that disclosure to file a provisional patent. That is only in the United States. I would say mostly all countries, you lose the right away. So please be careful on that, specifically when you are collaborating with other researchers or maybe an institution outside the United States that they would like to have the protection done in other countries. So please be careful with that. And then, of course, if you offer that technology for sale, the same thing. You have 1 year to file for a patent. So that's the main thing that I will ask you to be aware of and make sure that you have that in the back of your mind. Before 2013, it wasn't the first to file, it was the first to invent. So if you could present your research lab notebooks or anything like that that prove that you invented that technology before, even if you file after, you would have the right over that technology. After 2013, it does not matter when you've invented that. It matters when you file that. So that's when we want to be careful with that. And that's when we file a provisional application that is going to give you another extra year to collect and create further data. So we file the provisional, you work for a year, and then we convert it into a non-provisional if there is the need or not. That's a decision we made 12 months later. I would say that would be the main difference. Copyrights, an idea is not protected here, but the expression of the idea. So it's basically like literally dramatic music, theater, pictures, sculptures, that kind of protection that you're gonna have. It will exclude titles, names, symbols, phrases, anything similar that will be more into what falls a trademark. So trademark is when we're gonna protect the design, the look, so people will look into it and they will recognize it can be just a symbol like Nike, or it can be the symbol and the lettering. So everything in here is covered under trademarks. Like, for example, Jackrabbits. You can have just the Jack, or you can have Jackrabbit lettering, and you're gonna know that we're talking about South Dakota State University sports team. So then a trademark, as I said, it's words, phrases, symbols. It can be one, it can be both. And then a service mark, it's when you're gonna identify a service rather than a product. And the trade dress is when you're gonna protect how it looks. It's basically the design. So for example, here, everybody knows that's an iPod that's made by Apple. So they have that protected, and then nobody else can use that. For example, the design of the iPhone is another one that they have protected as a trade dress because it's the outside look. It's not a word, it's not a phrase, it's not a letter. You can registration your trademark, you don't have to. The big difference is that if you register your trademark, you're gonna be protected by the USPTO. And then if someone else wants to use that and you are registered, you can file opposition to that. And then of course it's gonna be decided. After 5 years, you can't file that opposition anymore. And then a registration will be examined by the USPTO and registered for as long as it's in use. If you will stop using that, you can go back into the public use and someone else might be able to use that. And then trade secrets, it's gonna be a recipe or something that has value that, for example, if it ever falls into the wrong hands, it's gonna be a huge economical harm for that specific company or industry or business. That's why you want to register. You don't have to, but you want to, because it's going to give you the right to fight if someone ever illegally make it public. So they're probably going to have to pay injunctions, royalties, compensatory damages. Of course, there are some of them that will be impossible to calculate. For example, if Coca-Cola secret ever comes out, their company is basically done. So then, just to recapitulate a little bit on what is the technology transfer process, the first thing to file will be an invention disclosure form that you can find in our website together with all the other agreements that Dr. Gibbons mentioned before. Once all of that is submitted, we're going to do a patent accessibility and a market accessibility. And after we do that market accessibility and patent accessibility, we meet with the professor again and we further discuss what will be the next steps. That can be if how early stage is your technology, if we need further development, if you're ready to file a patent, or if there is any industry that has already shown an interest to work with you, we can put an NDA, a non-disclosure agreement in place, and further discuss that. After the meeting is done, if there is the need, we're going to file the patent, and then, as I said before, you're going to have another year to further develop your technology, and then we convert that into a non-provisional, and if it's allowable, also a PCT application, meaning outside of the United States. And then again, as Dr. Gibbons says, the SDSU will distribute 50% of the royalties that will come back to the university after the tech transfer gets reimbursed for all the patent costs. So 50% goes for the president's office and 50% is shared between all the inventors. If you have one inventor, that one inventor keeps that 50%. If there are two or more, it's shared equally. And that, or sorry, not equally, it's going to be shared according to what the inventors decided in the IDF, in the invention disclosure form. There is a specific area where you can say who are the inventors and what is the percentage of collaboration of that inventor. So one can be 90% and the other one can be 10%. So those 50% will be shared accordingly to that. So this is a little bit of more curiosity. Those are the numbers from Tech Transfer Office as an average. Invention disclosure, and that's fiscal year numbers. So let's say invention disclosures, for example, 36 in the last year, 13 patents filed, and that includes provisional, non-provisional, conversions, and all of that, agreements that we have run, total licenses, and royalties that have come back from all different departments on campus. So if you have any questions, let me know, or Dr. Gibbons, and we're here to help. Thank you.